Welcome to Dolly Talk. This is Dolly. How is everybody doing? Hello, Mads. Ahoy. Ah, yes. Praise Taka to you as well. I am late, actually. Yeah, yikes. 3 minutes, shit. Okay, well, did not mean to be so late, but here I am. What up, Maddie? How you doing? Taka. Yes, we're all big fans of The Lion King. So we're going to do some Judge Simpson today. I don't have, Leighton Ricade, I don't have sheetrock on my nose yet. So there's at least that. Fun fact, though, I was at my psychiatrist yesterday and told them I'd quit drinking, and they were like, "Oh, okay, great job. So, are you doing any cocaine?" I'm like, really? Yeah, Mavka. Unfortunately, it's been delayed to the 13th. I was really looking forward to it, but he's not today. So I'm guessing it. Probably more discovery that the defense is still waiting for. Yeah, maybe she needed some. Wouldn't surprise me. Are you seeing Sigmund Freud? He hasn't mentioned my mother yet, so that's good. All right, so we are going to do some of the probable cause for today. A bunch of cases we can get through, see how many we can do.
Okay. Let's see what you.
The 14A District Court for County of Washtenaw, State of Michigan is now in session. All those have been for the court draw near. The Honorable Judge J. Cedric Simpson preside.
You may be seated.
Whoa.
Miss Lundy.
Holy Who is Jack Moniz? Good Lord, you just know that kid had to be bullied in high school. Wonder if he knows Alex Murdaugh. Oh, I didn't know Sigmund Freud was a coke fiend. That would explain it.
Good morning, Your Honor. After line for the people, at this time, people would waive any conflict in this honorable court in the office. Who does not believe that any conflict exists and make waiver for the avoidance of all ballots.
Thank you. Mr. Brown. She said that fast. Good morning. That's called efficient. Let's see what you do. No, go ahead. Good morning, Your Honor. Warren Brown, Deputy Public Defender. We likewise do not believe that any conflict exists in this honorable court hearing these matters. If a conflict were to arise, we would waive such conflict. Thank you, Mr. Brown. That was efficient.
The court, for its part, also does not believe the conflict exists either in Michigan court rules or the cases cited thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Robert Huff.
Good morning, Your Honor. Amy Reiser, appearing on behalf of the court.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Huff. Mr. Huff, can you state your name for the record?
We are getting him right now. He might not be able to do it. So Robert, I got you for a thing real quick. Yeah. I don't think this was.
What the hell's going on,
Is that
Robert?
Mr. Huff?
Yes.
Yeah.
All right. Defendant is present. Go ahead, Tom.
Your Honor, I received a report stating that Mr. Huff was incompetent and not restorable within the time frame. I would stipulate to the court and did prepare an order to the court for signature regarding that.
And will not, and is not restorable.
Take your freaking hat off, dude.
It's not restorable.
All right. Any response from the people?
No, Your Honor, I am not able to get into the county system this morning, but I would not dispute Ms. Apple's representation.
That is what the report reads.
Oh, so much.
The defendant is found incompetent.
How are the people
continent?
going to proceed?
So there's an option on there that we file a petition, and so I need to review the file to see if we will file a petition for commitment.
All right. So what I will do is I will,
I think check it and we'll get it filed.
all right. Well, the question is whether I set a new date
Hi,
so that
Robert.
we review it. Otherwise, it's just going to sit there if something falls to the cracks. So why don't how long will that take you think?
Excuse me?
Yeah,
Yes.
I'm here.
Hi. Sorry, I work here in the court office where Mr. Heft is hospitalized. I just want to let you know we have already completed the petition and certs to probate him. So it's already been completed with Washtenaw Probate Court.
Oh,
Thank you.
fantastic.
Then my
Like a
office
woman
will
that
file a
completes it.
petition. Thank you.
All right. Then what I'm going to do is I'm just going to find him incompetent and you'll have to at some point send a nollie processor.
No, I suggest you go back to school there, Judge. I'm not incompetent.
Okay. Thank you.
The letter or do you?
I'll do that this summer. All right. Thank you, Mr. Heft. Court does call the case. The people versus Andrew Cooper.
Aw. I just set up my entire screen for her, and she disappears.
And good morning, Your Honor. Uwe Daus on behalf of Mr. Cooper in both files.
Koopa.
There.
Oh, he's a
He's
Koopa.
He's at OVOC. He must have stepped out.
Oh, he's right there. Just yeah.
Mr. Krupar?
See him
Bowser
listed, but
needed
not in the
something.
room.
There? Yeah. My label is just covering that. Mr. Krupar? Okay, it's just gonna be that kind of day.
That's okay. I'll take a seat.
Huh? Okay, I'll pass it.
Thank you.
You see him wake up, let me know. Court does call the case, people versus Stephanie Woodall.
Andrew Childers appearing on behalf of the people, Your Honor.
Oh,
Assistant Public Defender Natalie Pate with and on behalf of Ms. Woodall,
Who
who
does
is
he
present
look
via
like?
Zoom from the MDOC. Ma'am, can you please unmute and state your name for the
who does
court?
the middle guy look like?
Stephanie
oh my
Joy
God.
Woodall.
Thank you.
Thank you, Your Honor. I'm respectfully requesting an
Oh, that is killing me. Who does he look like? Some actor.
adjournment. The people did extend an offer.
Or Rick Astley, maybe?
This morning, which I was able to convey and discuss with Ms. Woodall, but we just need a brief adjournment to get that written up for the court.
That is what?
Yeah, kind of like Rick Astley.
Probable cause conference will be adjourned February 13th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thanks, Ms. Woodall.
Thank you, Ms. Woodall.
Thank you very much.
Court does call the case, people versus
Oh,
Sean
the guy
Burrow.
Conan O'Brien. That too.
That's a lot of people.
Tintin. Want to say anything, Jack?
You have a wad? I have a controller.
Who'd you call, Your Honor? I'm so sorry.
Mr. Burrow.
It's Mr. Mawan's case.
Has he filed a substitution?
I don't think we were out of the house him this morning. We.
Is he intending on joining us?
He wasn't here early. Sorry, Judge.
It's okay. Everybody was pleased with waiting.
If you're going to send me away to the jail, you remember my cousin Vinny? He went in the school bus. I want the school bus. So.
Okay. All right.
Elias Muad appearing on behalf of Mr. Burrow.
You know, people are going to be nulling his case, so that
Oh.
will be so overshoot.
Better not object.
Then I will. I assume there's no objection.
No objection.
All right. So this case is dismissed and I'll sign the order when it comes in. Mr. Burrow, he almost blew it. I'm just saying. All right. Thank you.
Thank you, Judge.
Appreciate it.
Court does call the case, people versus Dion Baldwin. I think what's his name?
Nicole, do something on behalf of
Edward Drukas on behalf of Dion Baldwin. Good morning, Your Honor. Edward Drukas on behalf of Dion Baldwin.
Your name, sir?
Dion Baldwin.
Thank you.
Today is a day for PTC. I'm asking for an adjournment. I need to obtain the video in each case.
And that's already been requested on its way, I'm assuming.
What's that?
It's been requested and it's on its way to you.
Yeah.
Okay. Probable cause conference February 20th.
I'm asking for a PR bond.
Regarding the adjourn date, I'd ask for the soonest date. Is that the earliest date?
2/13.
Understand that we want to address bond.
25, 9 a.m. I'm assuming you want to address bond.
We would like to address bond at this
Okay.
time. Regarding bond, right now, I believe he's at a reduction on the bond. He's not able to pay it. He's looking to test corrections.
Response.
eligible for a PR bond. He was held on bond and one of the two files did not appear before Your Honor. Bench warranted well in absconder status with that bench warrant out for his arrest. He picked up the new case and now he's back in custody. So he's not eligible for a PR bond.
With that being the case, I'd ask for the soonest available date.
2/13/2025, 9 a.m. bond. Motion for bond reduction denied. Bond will continue.
I want to pay the bond then today. I have the money.
You can pay the bond.
Okay, so we're gonna pay the bond. Pay the bond this afternoon.
Sounds good.
All right. You know, if you have to bring Bill's bonds.
Thank you. I think did he wake up? No.
Hey, let's make us go with the ball.
He is.
Yeah.
Mr. Krupar? Mr. Krupar? He was up. I doubt some. And I guess not so much now. Mr. Krupar? No, he just moved. Are we sure he can hear me?
Are we sure he's alive, Judge?
Okay. You did email him?
Yes, sir.
Court does call the case of the people versus Samantha Cosley.
That's the people.
Cosley.
Hey, don't knock the Goths half Irish.
Ready, Your Honor.
And good morning, Your Honor. Joseph Hall appearing for on behalf of Ms. Klosik, who stands to my right. Ms. Klosik, if you could state your name for the record, please.
Samantha Nicole Klosik.
Thank you very much. And Your Honor, at this time, we have executed paperwork, and I've advised my client regarding her rights moving forward. She would elect to waive preliminary examination and proceed to circuit court.
This is a operating while intoxicated causing serious injury.
That's correct, Judge.
And does she have a medical marijuana card?
Your Honor, she has an expired one and she has an application.
Why is she using?
She has a warrant out.
Your Honor, we don't.
Mr. Allen.
I would not advise her to comment on that. But Your Honor, she does have a doctor who has certified, who has executed the appropriate paperwork, which is sent to the state. We believe that card is in the mail.
I didn't hear the question, sir.
When was that done?
That was done immediately after she exited Maple Grove, Judge.
Immediately after what?
She exited the inpatient facility where she was in between the last hearing and today.
Hey, Phil.
So we do have some documentation, Your Honor, from the doctor's office.
When did she get out of the facility?
I have precise dates in my file.
I went in on the 6th.
Yes, I believe it was the 22nd. Well, her appointment with Dr. Durinka was January the 22nd, Your Honor. So at that point, she was out of the facility.
When did she go in?
The 6th.
The 6th of January.
Oh, God.
Came out the 22nd.
Your Honor, it was close to, without going back to my file. I don't want,
That's fine.
Okay.
And then he's using.
With Dr. I understand, Your Honor. Yeah, I mean, I'm not going to dispute the drug test.
Counsel approach.
Yes, Your Honor.
Come on, counsel. All right, just skip forward. Come on. Ah, somebody told him a funny. Ah, there's Andrew Cooper. He is alive. Come on. Seriously? Jacqueline Jones is keeping his eye on him. Really?
These results.
You may want to mute. Yeah, if you were.
Not you, Jack.
Nature of this challenge, the fact that she doesn't have lawful ability to use that kind of both just keep and they're wondering if inpatient works, if you get out and use it. All right, she said we're going to assume that if we can get those today, we're trying to know how to get it back to something. Otherwise, we're going to do it very sure that you. Thank you, Your Honor. All right. Your Honor, I appreciate the bench conference in this matter. At this point, while we have a lot of what I would call circumstantial evidence of what we've already said, that there's been an application made, we believe it's going to produce a card. We understand Your Honor's position that right now, technically, we're in a legal gap there. And we understand the results of the test. We do not dispute the results of the test. I would ask for the shortest possible adjournment. Ms. Klosik was being tested while in the Maple Grove facility. We're going to get those test results and forward them to Your Honor as soon as possible. For now,
once I get those, I will reconsider the decision I'm about to make now. But given the nature of the charge in this case, with operating while intoxicated causing serious injury, she's using, prior to her going into treatment, there's cocaine and 2 other drugs in her system, comes out of treatment, and now I still have another drug in her system that cannot be tolerated and won't be by this court. So at this point, I will adjourn the probable cause conference to February 6, 2025 at 9 a.m. At this point, defendant's bond is revoked. Defendant's remanded.
And Your Honor, one more point. I do have a letter from her medical doctor regarding her future testing, stating the basis for a recommendation of swab testing. I can provide that to both Sister Counsel and Your Honor for when eventually she is released, and we're going to.
Well, if you hold on to that, then I'll certainly address it next week.
I'll send this with the test results, Judge, to all parties.
That'll work.
Thank you, Your Honor.
All right, thank you.
I'll talk to you.
Court calls the case of the People versus Russell Exelby.
Echelon for the people.
Ready, Your Honor. And once again, good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Exelby, who's now standing to my right. Mr. Exelby, if you could state your name for the record, please.
Russell Exelby. All right. I have before me a plea form. Is that what we're doing?
That is correct, Your Honor.
Plea form indicates that the defendant will be pleading. It doesn't say what type of plea.
Your Honor, the plea is an added count 3.
No.
That's his guilty.
Oh, he's going to be pleading guilty in this.
Thank you. So he's pleading guilty to an added count, well, the charged count 2, as well as an added count 3 of operating while intoxicated, second to 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed.
That's correct, Your Honor, along with the Killebrew requiring a sentencing into the 14A sobriety court program.
Yes, indicating that he must enter into and complete 14A sobriety court.
That is a correct and complete recitation of the plea agreement, Your Honor. As the court knows, count 2 does require mandatory forfeiture of the weapon.
Yes.
We understand that as well, Your Honor. We also agree that that's a complete recitation of the agreement in this case.
May I have in response?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Russell Exelby.
Has he signed any advice for us?
Your Honor, I believe that was executed actually months ago in this case.
I don't have one.
You don't have one?
It's always an issue, Judge. Yeah, take your time, sir. We're hourly.
Sign there. Date right here.
When's Bozo the Clown getting his case called?
Thank you, Court. Thank you, Judge.
Sir, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor offenses. Is that correct?
Correct.
First offense is the stated count 2 on the complaint, which is a charge of possession of firearms under the influence. That's a misdemeanor punishable by up to 93 days in jail, a $100 or $500 fine, depending on whether or not there was use or discharge of the firearm, and mandatory forfeiture of the device. You understand all of that?
Yes, sir.
All right. Also, it's this court's understanding that you're going to be pleading guilty to an added count 3 of operating while intoxicated second offense. That is a misdemeanor punishable by up to 1 year incarceration, a $200 to $1,000 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
Understanding all of that, and I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge in this case. You would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes, Your Honor.
All right. Now, understanding all of that, sir, do you still wish to plead guilty?
Yes, Your Honor.
To the charge of possession of a firearm under the influence, how do you plead?
Guilty.
To the charge of operating while intoxicated second offense, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Sorry?
You signed an advice of rights form today?
Yes, Your Honor. Yes.
Any question regarding any of those rights?
I don't believe so.
All right. On the podium, there's a copy of one. Please look at paragraph 5. Those are your rights which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Doesn't look like it's got a video.
Yes, Your Honor.
You understand you're giving up your right to appeal of it.
Yes, Your Honor.
Are you on probation or parole?
No, not this time.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce?
No, Your Honor.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And also because you believe that you're guilty of these charges?
Yes.
Well, and the threat of more jail time. If I
February 12, 2024, at the location of North Ann Arbor Street near Woodland Drive in Saline Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes.
All right. Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes.
Do you recall what you had and how much?
3 to 4 beers.
All right. Were you stopped by the police?
Yes.
It's always
Why'd they stop you?
They pulled me over for going 5 miles an hour under the speed limit.
Mr. Exelby, do you recall why the officer stated that he pulled you over?
He's smiling. The judge is smiling.
We're slowing down and going 5 miles an hour under the speed limit.
Did Officer Belknap also allege that you accelerated to 38 miles an hour in a posted 25 zone?
I don't recall that evening, no.
Are you disputing that?
I was in the police report.
Okay. Are you disputing it at this point?
No.
All right. Are you disputing or challenging the right of the police to stop you in this case?
No.
All right. Were you ultimately arrested?
Yes.
Okay. Were you taken to the police station or hospital?
Police station.
All right. Were you given a data master breathalyzer test?
Yes.
Your Honor, I will stipulate for the purposes of this record an intoxicator result of 0.176 and 0.174.
4 beers?
And so you have no reason to dispute those test results?
No.
All right. Sir, had you previously been convicted
of operating while impaired on or about April 20th, 2024 in the Chelsea District Court and or on May 1st, 2017 in the Adrian District Court.
Yes, Your Honor.
All right.
That's
And
true,
sir,
man.
did you have a firearm in your possession at that time?
Yes, I did.
All right. Where was that located?
It was unloaded and cased in the back seat of my truck.
Okay, but you did have that in your possession?
Yes.
And you acknowledge that you were under the influence of alcohol?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's pleas?
Equal satisfied.
Satisfied, Your Honor.
Court will accept the defendant's pleas. 2 counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report and screening and assessment is ordered at 14A4. Sentencing in this matter will be
February 11th at 9 a.m. before Judge Freshour.
February 11th, 2025, 9 a.m. before Judge Freshour.
Your Honor, and we're, just to clarify, the email that Mr. Heaton sent out to Sister Counsel, myself, and Your Honor, indicated that the following sobriety court docket where sentencing would be appropriate would be February the 13th at 8:45. I don't know if that's in error. I do have the email from Mr. Heaton.
We don't have that date, but actually what I'll do is I'll set the 11. Bond will continue. Actually, you can check. Mr. Heaton should be down the hallway.
Okay, Your Honor, may I also address bond before we move forward?
Sure.
Mr. Heaton's email is relevant to that as well. I'm happy to approach the court with the email if you'd like to see it. May I, Your Honor?
Yeah.
Thank you so much, Your Honor. Your Honor, the email.
I had 2 cases and they're taking an hour.
Your Honor, in this case,
David,
we have the sentencing date listed there in the email, but we also have Mr. Heaton stating that if either Mr. Exelby's bond were reinstated or whether he was given a PR today, that sobriety court would immediately take over his supervision moving forward. That would include testing as well as administration from the specialty court, which I believe would provide Mr. Exelby tools for moving forward. We would ask for Your Honor to consider changing bond, given Mr. Heaton's statement and the fact that Mr. Heaton has already been able to evaluate Mr. Exelby while inside.
I'm not at this point going to change his bond. I understand what it says here, but I'm not going to change his bond on that. I'm going to leave that to Judge Freshour.
Understood, Your Honor.
So motion for bond reduction is denied. Thank you. I will change the date on that email to the 13th.
Okay.
At 8:45. Although we don't have that date, I do see that in writing, so I'll set that.
Thank you, Your Honor. If something's incorrect, I'm sure we can work with the people in Judge Freshour.
Yes.
Take care, Your Honor.
All right. Thank you. Court calls the case. People versus Jacqueline Jones-Washington.
Supposedly up to 3 months, but I'm guessing not much time.
Who's on it? Jones-Washington. I have her. I don't have, who's counsel?
Mr. Gaddy's right.
Oh.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender for Ms. Jones-Washington.
Washington, can you state your name, please?
Jacqueline Jones-Washington.
Thank you.
Your Honor, this is a time and date scheduled for a competency hearing. We are in receipt of the competency evaluation from the Forensic Center. I don't have anything else to present. I don't object to its admission.
All right.
I have met with Ms. Jones-Washington and discussed the matter with her.
Any response from the people?
No, Your Honor, the people do not study.
All right. We find that the defendant at this time is incompetent to stand trial, but likely will obtain competence with proper treatment. Once I receive an order, I will sign that. I'll set a competency review hearing date for give me 90.
May 1st at 9 a.m.
May 1st, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you. Court does call the case of the People versus David Fuhrman. BG case.
God damn it, David. You better ask Ella. No, you know what? You can publish it, David. God damn it. You might as well publish it now. Thank you, Half Irish. Yeah, David, just publish it. But don't tell Hella I gave you permission.
I'm here.
Yes. The Attorney General, can you put your appearance on?
Yes, Your Honor, I couldn't hear anything. Yes, good morning, Assistant Attorney General Clarissa Williams on behalf of the people.
Good morning.
Good morning, Your Honor. Edward Drugas on behalf of David Fuhrman.
All right. What are we doing?
Your Honor, I'm asking for an adjournment. I'm looking to facilitate conversation with Ms. Williams. It's switched over to a couple different prosecutors, so.
All right.
We've been exchanging emails.
Probable cause conference, he's out.
Yeah.
Probable cause conference, February 20th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Your Honor, while I have you, I have another matter before the court. Mr. Brian Brown.
Is he in custody? Oh, we don't usually call him that way. Where's his case? Is it? Oh, it's the next file. So if you just waited, we would have gotten it. But that's okay. Don't worry about it. Not a big deal. Court calls the case. People.
Assistant Attorney General, or the Attorney General is the top Attorney General of any state. God damn it, David. I'll play that in a second. First of all, so yeah, the Attorney General is like the head law enforcement of each state. So like each state has a chief like law enforcement bureau. So, but every state's a little bit different. So the Attorney General's office, and these would be like the prosecutors under that Attorney General. So kind of like prosecutors under a DA. He used to stream, but he kind of does occasionally. Hold on, guys. All right, you... Fine, I'll show the freaking thing David did. Hold on.
Hi. I'm looking for a white lady that's tattooed and dominant and be willing to put me in a dress and beat the shit out of me. Call me.
Hello, everybody.
I hate you so much, David. I hate you so much. All right, you... Fine, I'll show the frick... God damn it. Oh, wait. Thing David did. Hold on.
He signed an advice right for.
Yes, Your Honor.
I don't need to have the. Go ahead. All right.
plea form indicates that he's going to plead guilty to an added count of use of a controlled substance, a 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed, and that it's okay for him to seek 7411. However, I cannot bind the sentencing court to that. That's the court's full understanding. Is that correct, Mr. Dukas?
Yes, Your Honor.
May I have him sworn?
Raise your right hand. You can solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Tory Brooks. Sir, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. You understand that? Yes. Understanding. And you also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in 14B District Court. You understand that? Yes. Still wish to plead guilty? Yes. And to that charge, how do you plead? Guilty. Now you understand that by pleading guilty, you'll not have a trial of any kind? Yes. You signed an advice of rights form, is that correct? Yes. Any questions regarding any of those rights? No. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Yes. You understand you're giving up your right to appeal of it? Yes. Are you on probation or parole? No. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? No. Anybody threaten you or coerce? No. You're doing this voluntarily? Yes. Of your own free will? Yes. And because you believe that you are indeed guilty of this offense? Yes. January 21st, 2024, at the location of South Harris Road and E Course, Ypsilanti Township, Washtenaw County, State of Michigan. Did you have cocaine in your possession? Yes. Had you used it? Yes. Did you know what you were using was cocaine? Yes. Counsel, have I complied with the courtroom?
Right now? Yeah, he's still live. I'm going to go to that. If that's the case, I think it is. Because there was maybe a week or two, I remember watching Simpson, and there was a interesting case that kind of just involved yes, a wood chipper. So it might be this one. I will.
And then behavior to, because I'll put it.
So
the defendant said he would pay him $20 for
be a different picture. By interpretation, certainly of what
discretion, but there are 3. Yeah. But before he's been arrested or
obviously we're.
Okay, I think I found it.
Court's concerned or anything at that point.
Versus Redcliff. Counsel is present along with the defendant. Thomas, you may proceed.
Thank you, Your Honor. And Judge, I'd just like to address what we were last talking about before you left. And
yes, sir.
It's page 5 with victim B and victim B. And I went back and I've looked at these things. And again, Judge, if the court has any concerns regarding my client with that type of contact, the one thing I would remind the court of, one, if it did happen, then I would say, obviously he wasn't under a court order or anything at that point. And so I understand the court's concern, but we would be willing to, have no contact orders, take away, and give up on any electronic devices, no phones, no computers, none of that. And I think that would obviously put to rest any possibility of him. And obviously, if he violated that, he would be right back here in jail. It would not be wise for him to do that. It wouldn't be wise for him to contact that. And honestly, Doug, it would be contrary to what I would advise him to.
Well, so right. And I don't, let me make myself clear that I'm not saying that he violated a condition of bond. I'm not saying anything along those lines. I'm saying what troubles the court is that behavior where there are these allegations that are out there, and then behavior to, because I'll put it in the colloquial, just to either cover up or interfere with and or obstruct an investigation. That's what bothers the court. I'm not saying that he should be charged with anything. I'm not saying that. I'm just looking at the behavior of the defendant, because that's what I've got to bank on if he were to be released. And I'm pointing out what at least is alleged, a behavior that is very troublesome for the court.
Does this go to risk to the community, Your Honor, that you're talking about?
It certainly goes to risk to the community, and in my experience, also would go to the issue of, can I trust this person to not flee? Because in some way, this can amount to some type of obstruction of justice or some type of interference with an investigation. And do I believe that that person, assuming, and I'm not saying, not trying to necessarily make an accusation, but if somebody were to do that, can I trust that person not to flee the jurisdiction?
And again, Judge, I'm sure you've been doing this a long time. I've been doing this an awful long time myself. I've had, this is not my first bond hearing. I understand the court's concerns, and under the circumstances when you have somebody that's got no prior criminal history whatsoever, you've got somebody that's never lived outside of Michigan per se, other than being in Virginia for Liberty for school for whatever that time period was, that has lived here his entire life. His entire family resides here. He doesn't have a passport. So it's, with the lockdowns that they have today, I mean, it's probably pretty impossible to try to get off of, out of the United States without a passport. And obviously going anywhere else in the country, with the computer system, the NCIC and everything else that's out there, it's almost impossible for somebody to just disappear and never be found again. It doesn't happen. I mean, I don't think I can think of one case where I've ever seen as an attorney where somebody didn't show back up.
But counsel, it isn't even the issue of will they be found again. It's the issue of will you attempt to try to flee the jurisdiction. I mean, and it's a slight distinction, but there's a distinction in it. So
I'm just saying, Your Honor, with the bullet points that I've already presented to the court, that he's not an alcoholic, he's not a drug abuser. He's had a job his entire life. He's got family and friends here. There's nowhere for him to flee. He's not going to flee. I don't think the court has anything to worry about with the fleeing portion of this. And I don't say that lightly, Your Honor, because I understand the severity of these charges. I get the concerns of the court, and I don't take that lightly. I don't take my position as his attorney lightly in that matter. And so, I drive 2.5 hours to get here every time I come here. I certainly don't want to represent a client that I would think is going to flee the jurisdiction and not do what I'm telling him and directing him to do. And I certainly would direct him to make sure that he's in court. He knows what the evidence is at this point, Judge. And I told him, obviously we're here to defend this, and he's here and he wants to defend it. And obviously that is our goal, is to get through these PCCs, get through the preliminary examination, and let the chips fall where they fall. And then we get through the preliminary examination, and if any charges that still exist after a preliminary examination, then we'll deal with that in circuit court. So obviously, our position as judge is that he's sitting in jail for 105 days. The evidence in this case just, to charge people with CSAM, not have any CSAM, just doesn't make any sense to me. And then to file more charges for the same charges without knowing that you didn't have any CSAM doesn't make any sense to me either. So in light of all that, Your Honor, just the magnitude of these charges that are presented on top of him doesn't mean that, hey, there's more charges I'm going to take, possibly be a flight risk or a danger to the community. He wants to face these charges. He wants to exonerate himself. That's what he wants to do. And so with that being said, Judge, my client is going to appear for these court dates. He's going to appear with me. And again, he's got all these people that are supporting him. He's got the letters that were presented to the court. He's got a place to stay, and we will give up any electronics. We will give up anything the court wants. If you want to put a tether on him, we'll put a tether. We'll put him, no contact orders. Take away all electronics. Anything that the court would make it feel safer for him to be out. He's going to get a job, and he's going to go to work, and he's going to live with his family. He doesn't need to have access to any of that stuff. So the court can put those no contacts, and if he violates, then throw him back in jail and keep him there. I have no problem with that.
Thank you. Ms. Ryder.
Thank you, Your Honor. I would indicate to the court that the defendant was arraigned and arrested on or about October 20th, 2024. At that time, Magistrate Fink set the bond at $3 million, no 10% cash or surety. Once the defendant was arraigned, additional victims did come forward. At the time of arraignment, he was charged with 1 count of criminal sexual conduct in the first degree, with 1 listed victim and additional approximately 11 additional counts of child sexually abusive activity and using a computer to commit a crime with different victims than the listed victim for the criminal sexual conduct first degree. When the additional victims came forward, the defendant is now, after the arraignment and the bond being set at $3 million cash or surety, facing 6 additional counts of criminal sexual conduct in the first degree, with 2 separate victims. And I state that because the court rule in the statute allow this court to deny pretrial release of a defendant charged with criminal sexual conduct in the first degree if the court finds the proof of the defendant's guilt is evident or the presumption is great, unless the court is presented with clear and convincing evidence that the defendant is neither a flight risk or a danger to the community. And I would submit to you first and foremost, Your Honor, there's no abuse of discretion in the magistrate setting the bond at $3 million. But if we're going to look at the bond that was set at $3 million, the things that have changed since that bond was set is additional victims that come forward. So it would not be appropriate to reduce the bond. And in fact, the people are requesting that the bond be denied because there's no clear and convincing evidence that the defendant is neither a flight risk nor a danger to the community. This information in the investigation began on or about August 26, 2024, when it was reported to the police department, to MSP. One of the victims reported to the defendant's girlfriend at the time the things that the defendant had done to him. When his girlfriend at the time confronted him about that, confronted the defendant, she had a 6-hour longer conversation that night discussing the victim that had come forward. The defendant told her not to believe a word that he said, and he left her house around midnight. He told her that it was best that she not tell anyone that the majority of their conversation was about that victim. And he reminded her that they still had a 2-week break left in their relationship and not to contact him. Another victim came forward, and that's when she broke up with him. After that conversation, on August 30th, 2020.
Excuse me one moment, sir. Counsel, when you want to talk to your client, make sure to push the button on the top. Yes. These microphones are very sensitive and I don't want a conversation to your client. Go ahead.
On August 30th of 2024, the defendant then called that victim 8 times and told him that he needed to keep his, quote, fucking mouth shut, end quote, because there was no information that he could tell him. And that's referenced in page 8 of the people's motion. So this is information that the defendant, that we have during this investigation. This is how he's acting when he's not been charged, when he's not been arrested and not been arraigned. He is intimidating and threatening the victims. And I would submit to this court that he is a flight risk. During the investigation, on October 21st, 2024, the Michigan State Police interviewed the defendant's parents. He was informed by the defendant's parents that the defendant went to Virginia after news of this broke. He may have stayed with his college friend, Phil, whom he knew from Liberty University. His mom thought that she went to stay with her sister, Rhonda, in Indiana after he left Virginia and gave Rhonda's address. Rhonda dropped off 2 suitcases of Zach's to Frank and Robin. Frank went through the luggage and found a MacBook inside. The trooper took custody of the laptop. Robin and Frank did not know the passwords to any of the devices. The defendant's mom cried during the interview and said that Zach had been leading a double life.
Counsel, I don't want to interrupt you, but I want to make sure that I'm understanding this. In October of 2024, the defendant, after the investigation starts to happen, he leaves the state to go to Virginia.
Correct. Around the time that the news broke, but before he's been arrested or arraigned, he left and went to the state of Virginia.
Okay, so when you say the news broke, when it became public.
I don't know exactly when they referenced, but I'm presuming sometime in the end of August, beginning of September, when everyone in the community, the church community, and the victims started coming forward and reporting to the police.
Okay, and so he left the state, some thinking that he's in Virginia, others thinking in Indiana, irrespective of that. For how long a period in time was the defendant not in the state?
I don't know the answer to that. They had just started to take the investigation and interview these victims. And when he was ultimately arrested, when the police arrested him after the conversation where he made admissions to one of the mothers about having these boys send him pictures of themselves masturbating, and he would pay money for them. When he made those admissions that are on tape that will be played at the preliminary exam, he was driving a rental car and had multiple electronics in the rental car that were seized. So that is our evidence, our indication that he is a flight risk. So
I'm sorry, but the rental, or he was arrested in the state of Michigan.
Correct.
All right.
In
a rental vehicle.
Dundee. In a rental vehicle.
In Monroe County, down in Dundee.
Yes.
Okay. All right, go ahead.
So that is just some of the information that the people believe that the court can consider and show that he has a flight risk. Beyond that, Your Honor, counsel talks about just because of the number of charges that the people bring doesn't affect bond, and I think it does. In this case, the allegations are, and the evidence will show that the defendant abused his position of authority at the church. So it's not, we don't have one victim or two victims, we have multiple victims spanning over a year period of time. So he is a danger to the community, and the people's position is if he were released, he would be contacting these victims, and there's nothing to stop him from contacting. Sure, there's a court order and we can violate his bond if he does it, but the appropriate thing in this case and the multiple counts of criminal sexual conduct in the first degree allow for this court to deny the bond. And that's what we're asking be done. The statute, the jury instruction on criminal sexual conduct in the first degree concludes that to prove this charge, it is not necessary that there be evidence other than that of the victim, if that testimony proves guilt beyond a reasonable doubt. So the victims of the criminal sexual conduct can come here and testify at preliminary exam. They can testify at trial, and the defendant can be convicted on it. There's not one victim of criminal sexual conduct in the first degree, but there are three. And so I don't believe it was an abuse of discretion to set the bond at $3 million. I do believe, based on the evidence in this case, that he is a danger to the community and, moreover, a danger to the victims in these cases. So I don't think it should be reduced. And we're asking that, pursuant to the statute and pursuant to the court rule, that it be denied.
Thank you. Response.
Yes, sir. So going back to the arraignment when he was actually given the $3 million bond, obviously the court didn't have access to what we've given the court, which is the doctor's report for one, the letters of support and all these other things that are out there too. There was no discovery that had even been conducted at that point. So whoever the attorney was that was arguing on behalf of my client at that time didn't have anything really to hang a hat on to make any kind of argument whatsoever at that time. But some of the things that the prosecutor just said in regard to this investigation in October, she doesn't know what the dates are when he was gone, when he came back. He came back to face the charges. He wasn't arrested somewhere else. He drove back here to face the charges. So he's not a flight risk. If he was a flight risk, he would have stayed where he was at. He obviously came back here to do the right thing, and that was to face charges. And he cooperated with law enforcement. There is absolutely nothing that the officer in this case wrote in his report to say anything other than he was cooperative. If he was a flight risk or if he didn't cooperate with at the time, that would have been written in the report, and it's not. It's not written in the report anywhere that he was uncooperative or anything else. He absolutely came back and faced the music and got arrested, was even in the front seat of his vehicle, handcuffed in the front, from what I recall. Maybe he was in the back, I don't know. But, obviously he came back, to face the charges. So he's not a flight risk. And again, he doesn't have anywhere else to go. As I said to the court already, there are so many different things the court can impose. You take his driver's license away, you take electronics away, make a no contact order. He is not a flight risk. He's not going anywhere. And again, going back through the answer to
what was he doing in Virginia, and how long was he in Virginia, and did he end up in Indiana, and how long was he in Indiana?
You probably got to drive through Indiana to get to Virginia, I think.
No, being a Maryland terrapin, you don't have to do that. In fact, you stay as far away from Indiana as you can.
I'm not from here.
So, So what was he doing in Virginia?
And he just reminded me what he went down there because I think that he had friends that were in Virginia, and he went down there to visit a friend, and he came back. So it's like a vacation that he was on, which is allowable, Judge. I mean, if you're not
I'm not saying it's not allowable, but counsel, you're leading this court to believe, and I'm not saying it may just be semantics, but you're saying to me he's only resided in the state of Michigan. I get the whole schooling thing, but that's not true. He resided in the state of Virginia. Then when all of this is at least brewing, from what I understand, and is out in the community, he then takes back off to Virginia and or Indiana, or at least some, I don't.
From my understanding, it was only a week, Judge. It wasn't even, I don't even think it was a week. Because he was back here, I think he was arrested on the 20th of October, was the arrest date. And I think that it was, it was only for a few days, maybe from the 15th of October to the 20th, something like that. Might have been a little longer, but I'm not sure what the dates were. But I know that he drove back on his own accord and came back. So there's nothing that anybody can say to the contrary to that. And, if he drove back here knowing that there was an investigation going on, if he was going to be a flight risk, then why would he drive back here? If his intention was to go to Virginia and say, I'm not going to face the consequences, then why didn't he just stay there? He came back to face the charges. So, the flight risk thing it doesn't work. And again, Judge, I'm not trying to play semantics on the court whatsoever.
No, I'm not saying that you were trying to play a game with it, but I'm just saying my interpretation, certainly, of what you're telling me gives me a different picture. That may just be how we view the world. That's fine. But prosecutor does bring up a good point, and I don't know what your response to that would be, that at the time he's arraigned, there are a certain number of charges that are pending. The bond of $3 million is set based upon those charges. Additional charges are then filed. His bond remains the same. They don't ask at that point to up bond. But as it sits before me right now with basically these competing motions, given the charges, and it kind of shifts in terms of one's burden, why wouldn't I grant the prosecutor's motion to deny bond unless I have before me something that is clear and convincing that he is not a flight risk and that he is not a danger to the community? Why wouldn't I?
And I would agree 100% with what you're saying, Your Honor, except for the fact that all the bullet points I've already presented, I don't want to beat a dead horse here, but again, if you look at the answer in her complaint, that she can either admit or deny, for one, the meat and potatoes of my argument in 6, 7, and 8, she doesn't admit or deny any of those. So if you can't deny them outright, then your case must not be that strong if you can't deny it. She obviously doesn't have the proof.
Yeah, but that's not my standard, is it, under the rule? I mean, the charges have been brought, and if I believe that there's a likelihood of conviction, then certainly I can go one way. But on the charges, certainly I could deny bond unless there is clear and convincing evidence that he does not pose a danger to the community and or flight risk.
Right.
And I'm getting, and counsel, and I'll just tell you, I mean, I sit here and I cannot certainly predict the future. That is not my job. But I certainly have to look at a person's behavior to try to assess what is the likelihood that that person will do it. And I'll be honest with you, I'm not getting really satisfactory answers to his home Virginia connection, to where was he? And you're saying it's a vacation or whatever, but okay. And the contact with individuals and what he's saying to those individuals, knowing this is going to happen. I'm a bit hard pressed to say that that person doesn't pose a danger to the community in terms of what he will do. But I'm more than willing. I mean, I'll stay here as long as I have to. I'm more than willing to hear all of that. But those are things that go to those core issues of, does he pose a flight risk? I understand he has no criminal record, so I don't have that. But when all of this is going on, why does he take off to Virginia? And then these people, maybe this is wrong, who are so close to him, they're not really sure where he is. Is he in Virginia? Is he in Indiana? Cheap suitcases for 5 days? I don't know.
If he came back.
I guess on how you pack.
With my wife before either.
Pardon? Well, yeah. But that's.
Well, is it a kid he met?
That's
did he say?
Problem for the court.
Well, the only thing I can say, Your Honor, to this is this: if the guilt was evident and presumption was great in this case, we would have way more evidence to look at.
But counsel, here's the thing: as Mr. Reiser was pointing out, if one of these victims gets up and says, "This happened to me," and lays out a series of events and series of facts, then certainly he could be bound over to stand trial, and certainly a jury could convict solely on that.
I mean, you convict on circumstantial evidence. I don't disagree with you, Judge. Circumstantial. I can make an allegation against anybody.
Yeah, correct. But then, counsel, and I get that the number of charges don't matter. But what the court also, in looking at that particular issue, does have to take into account is the people's rendition in their motion there is this repetitive predatory behavior. Realistically, as our society is under circumstances that are really troublesome because of his position and these young adults. But it's not just one. I mean, there are just these numerous people, or like victims, but an odd commonality to what they're saying. And maybe not so odd, but it's certainly a commonality as to what they're saying. That's anything else you want to say as to under the rule as to whether or not the court should strongly consider the people's request that I deny bond? Is there anything else you want to say?
Your Honor, I just think that, based on what I've already presented to the court, with the low risk coming from a doctor in your jurisdiction, that maybe he's even been in front of this court, I don't know. But I mean, obviously she put him as a low risk. I think that should weigh heavily on the court. I think that, his prior record, the fact that he doesn't use drugs or alcohol, that he has his entire family here, that he could get a job, that we're willing to let you take the electronics, no contact order. I think that
if he got a job, counsel, what would he be doing?
He's got a really good attorney.
I mean, he could.
Would he be around people, young people, or people younger?
Not be around any young people, and the court could order him not to be around. That wouldn't be a problem. It's not any problem whatsoever. If you want to put him on house arrest, put him on a tether, he's willing to take that as well. You take his driver's license away and make him have to get fired.
I'm aware of what I should.
Well, if he's going to jail for 2 decades, I don't think.
Saying that there's ways that the court could obviously make it assure that if he bonded out, that there's not going to be a threat to the community and he's not a flight risk. And I think that we've submitted many letters of people that have known him his entire life, friends and other people. I mean, he's got a whole courtroom of people on this side over here that are here to support him. And, and just the fact that he came back from Virginia and drove back here, which he didn't have to do. If he was going to get flight risk, why would he do it? He's here. He did not try to stay gone. He came back saying, hey, I got to go back up there and I got to pay $15. And he came back. And that should be the telltale right there, Judge. I think that, weighing these factors into place and going, okay, well, you might be a flight risk. Well, everybody can be a flight risk. Anybody. You could have sitting on sidewalk charge and be a flight risk. But, I understand because of the type of charges that we're looking at, it's going to be scrutinized much harshly. And again, I think that we presented enough to this court, and getting a doctor to come in and see him in the jail and going through all these different things that we did. And again, this is my first try at a bond with this court. I didn't represent him at the arraignment. This is the first time it's been addressed in almost 105 days. So, this is our first shot at, asking this court to reconsider a $3 million bond. His family doesn't have $3 million to post a cash bond on this type of case, Judge. And, again, it's tantamount to no bond. So, and it's not
which can be appropriate in cases like this. You keep saying that, counsel. But I mean,
if the evidence is great and the production is great, if it's guilt is evident, then yes. But again, Judge, you've even said that, it's a circumstantial case at this point.
I haven't said that.
Well, I'm saying this.
I did not say that.
I know. I didn't mean to say. I'm saying that it's a circumstantial case at this point. And so, if the evidence was overwhelming at this point, where we had all this stuff that was just coming at us left and right, obviously, I would be in a very different position. If I didn't think I, had to hang up here, I wouldn't be doing this right now. But I've looked through all the evidence. I've seen what they have. And I mean, obviously, my client's innocent until proven guilty in this case, and he has a right to go to trial if he wants to go to trial. And obviously, he has a right to go through the preliminary examination, and we're going to hear from witnesses. But again, putting a $3 million bond on a case where there's not any CSAM and there's 33 counts, that involves CSAM, or a lot of them anyway, not all, but it's just one of those things that I think the court should consider that a reasonable bond in this case, which is guaranteed by our Constitution and the Supreme Court the Court of Appeals of Michigan, the site that I cited to the court earlier, guarantees you a reasonable bond. And if the guilt is not evident and the presumption is not great, then you have to move on to the next prongs, which is whether he's a flight risk or danger to the community. And then even if the court deems that doesn't mean no bond. You know, obviously you can put a higher bond on him, but again, an unreasonable bond for a guy that's indigent at this point, he doesn't have, his truck got repossessed.
Okay.
He doesn't have a home, have anything.
Good argument. I'm gonna
Could be a flight work to consider it.
skip.
It is not disputed.
The prosecutor.
I do, Your Honor. I do. It is not disputed that after these allegations started to surface, but before the defendant was arrested, that he left and went to Virginia. Whether he went there for vacation or to dispose of evidence, he left the state of Michigan. When the defendant was arraigned and charged, additional victims came forward. And I'm going to provide the court with an offer of proof of what one of those victims will testify to. And at the conclusion of that, I will ask that his bond be denied.
Right.
The victim was jealous of Zach because Zach was a cool guy at the church. Everybody talked to Zach, and he seemed like he was a safe space for people. The victim got an iPad Touch for Christmas when he was 14 years old, and he got Snapchat in February 2015. His parents did not want him to be on social media, but he defied them and got a Snapchat account anyways. The victim's handle on Snapchat was this. Zach, the defendant, added the victim on Snapchat, and he talked on Snapchat. Around June 2015, the defendant asked the victim on Snapchat if he had abs, and he asked for a photo of the victim shirtless. The victim sent the photo, and Zach told him to delete the photo from his phone. The victim did this. A few days before the first incident, the defendant asked the victim on Snapchat if he knew what a blowjob was. At that time, the victim kind of knew what it was. The defendant asked the victim if he would ever want one. The defendant offered to go on a drive with the victim and they could listen to music and talk. They hung out alone only on 2 occasions. The first incident was a Saturday night in July of 2015. The victim was 14 years old. He remembers this day because he went to church the next morning. On Snapchat, the defendant asked the victim if he had ever gone out late at night. The victim was bored and wanted to go out. In the middle of the night, the defendant drove to the victim's house. The defendant was driving a smaller sedan. The victim snuck out of the house and he got in the defendant's car. The defendant was in the driver's seat and the victim was in the front passenger seat. The victim remembers where they drove, on Calder Court, and parked on a street south of Harper Drive, so they were still near the victim's house. The victim was wearing loose shorts and he was a virgin. The defendant put his right hand on the victim's left thigh and began to rub it up and down his leg. The defendant asked the victim about blowjobs. The defendant made it seem like blowjobs were a thing that he did with his friends. They called them bro jobs. The defendant touched the victim's penis over his short and with his right hand. The defendant used his right hand to pull down the victim's shorts and underwear to his feet. The victim said he froze out of shock because he didn't know what to do. After the defendant pulled his underwear and shorts down, the defendant touched his exposed penis with his right hand. The defendant leaned to his right and put the victim's penis in his mouth in a sucking manner. He sucked on the victim's penis for 3 to 4 minutes. He stopped sucking on the victim's penis when he ejaculated in Zach's mouth. The defendant asked if he was okay and the victim said he did not know. The defendant asked if it felt good. The victim said he felt weird. The defendant told the victim he did not have to do it again, but he wanted to give him a space to feel good. The victim asked if he could go inside. And the defendant was okay with that, so the victim got out of the car and went back to his house. Said he could not sleep that night. The next morning he had to go to church and Zach was there. They did not talk about what happened the night before. His parents didn't know he snuck out. The victim said he was scared because Zach was a bigger guy. The second instance occurred in...
Oh yeah, that is the family in the back. Oh. Ooh. Man, that guy in the glasses looks like he wants to go Gary Plauché style on it. Oh.
2016 when the victim was 15 years old. They were still on Snapchat, and the defendant alluded to engaging in more sexual activity, but the messages did not use the word sex. The victim would confide in the defendant about getting in trouble with his parents, and the defendant picked him up in the middle of the night. He instantly came down to get the victim. In the same sedan as the incident before, the defendant was in the driver's seat, the victim was in the passenger seat. They drove to Oakwood Church's building. currently the Washtenaw Christian Academy. They pulled into the parking lot. The defendant asked the victim if he'd ever given a blowjob, and he said he did not. He kept pestering about giving a blowjob, and the victim was hesitant and told the defendant he felt weird. The defendant pulled his own pants down and said that the victim should suck his dick. And the victim said, I don't know if I want to. The victim froze again and the car was silent. A few seconds later, the defendant started masturbating while the victim was sitting there. The defendant whispered to him, you should help, and the victim didn't move. The defendant put his right arm around the victim's shoulder and neck. The defendant pulled the victim toward his lap, and he felt like he did not have a choice. The victim sucked the defendant's penis for about 2 minutes. The defendant had his right hand on the back of his neck, and if he tried to sit up, the defendant pulled him back down. This ended when the defendant ejaculated in the victim's mouth. The victim turned to the right, opened the passenger door, and threw up. The defendant asked, why'd you do that? And the victim did not respond. The ride home was silent. He dropped the victim off. The victim did not sleep that night. He had nightmares. He was scared for his life because he thought Zach had a gun. Before this, he said Zach always had a gun on him, but he did not see a gun on this night. His parents didn't know about it. They forced him to go to church. He would see the defendant at church every time. The defendant would tell the victim they shared a cute little secret. In a span of a few months after the second incident, the defendant texted the victim to see if he wanted to meet up, but the victim declined each time. Then the defendant started to ask him for videos of him masturbating. He didn't send any. The defendant in June of 2015 asked the victim if he'd ever sent a nude photo before. The defendant offered to send the victim a photo of him. The defendant said he would pay him $20 for the photo, so the victim sent the defendant a photo of his penis on Snapchat. The defendant gave him $20 cash for the photo the same night of the July 2015 incident. During the trooper's interview of the victim, he teared up, his body shook, and he took a deep breath and long pauses. He said these events were hard to talk about. We're asking that the bond be denied. That's one victim's testimony that I anticipate you will hear at this preliminary exam.
Of course, I'm going to take a brief recess, read over the documents, the letters that you sent, make sure I have that, take a look at it. I will come back and give you 14 minutes. All right.
Wow. Whatever, David. Let's skip forward to his ruling.
To county.
God, you guys weren't kidding about that.
All right. 14th District Court for County of Washtenaw State District is now back in session. The Honorable Judge Jacqueline Jones-Washington.
You may be seated. Right now.
Always.
We're back on the record in the case of the People State of Michigan versus Zachary Redcliff. In this case,
May God have mercy on your soul.
there are, in essence, competing motions regarding the defendant's bond. The defendant is asking that his bond be reduced, and the people are asking, to the contrary, that his bond be not effectively, but denied in this case. The court rule is very clear and very specific in terms of when the court can deny bond to an individual. There's a statutory section which applies to it, as well as a court rule. Specifically with reference to the court rule, the court may deny bond to a defendant that is charged with criminal sexual conduct in the first degree armed robbery, kidnapping with the intent to extort money or other valuable thing. Thereby, if the court finds proof of the defendant's guilt is evident or the presumption great, unless the court finds by clear and convincing evidence that the defendant is not likely to flee, or
present a danger to any other person, or what one may say, a danger to the community. The court can take a number of factors into account, and I've given, I think, each side an opportunity to respond to the court's inquiry as to what was going to be important in terms of the court's deliberation. People have done, well, both parties have done an excellent job in laying the issues that the court needs to decide before the court. I would say that the people's rendition of the statements and stories, at least the minimal synopsis of the statements and stories of the alleged victims in the case, are indeed compelling to the court. And one of the first inquiries that the court had was, as the court sees the whole thing, what really is a grooming and predatory behavior as you see each of these incidents. The court does take into account also that the defendant's position within the church and access to the youth play a factor in that, as it does in cases where there are children involved and certain behaviors, threats, if you will, enticements, other things can come into play. What is also of note, and something that the prosecutor brought up and I think does bear noting, is that the defendant's bond initially, when the initial charges were filed and the arraignment was set at the $3 million, the current bond that it is set at, did not take into account the additional charges that came forward. So this is really, in essence, the first addressing a bond with the additional charges of the additional individuals. I say that because I want to make it very clear that any change by this court is not based upon it's based upon the motion, not based upon any abuse of discretion by the magistrate in terms of initially setting the $3 million bond. But the rules, in essence, well, defense counsel is correct in pointing out that one looks at an individual's release and their ability to have bond or to be in a position to post bond and not restrict their liberty, except under those limited circumstances. And then it is almost as if and it is up to the people at that point to show that the defendant should be incarcerated. In limited circumstances, that in some ways shifts the burden in looking at certain things shifts. For example, in a crime of treason, violent felony where the other predicates are met, and then in certain types of cases where there is an analysis of whether guilt is evident or where the presumption is great. Given what this court has heard and the motions that have been filed and the information that has been put before the court does find that there is a great presumption that the people have established a great presumption of the defendant's guilt in this case. I would also indicate that the court is taking into account that the behavior is indicated, at least is laid out here. And I don't know what would happen during the course of testimony, but what has been laid out shows, I don't only want to say classic predatory behavior, but it in a lot of ways is, where individuals are basically these victims are placed into that position. Certain threats, either said or unsaid, are then placed upon these individuals, and then these individuals don't come forth. As the proffer indicated, that was put forth by the people. If that's true, and if the evidence, I should say, bears that out, one can see what the court is talking about with reference to an individual that is a young person who is forced to engage in sexual acts, who's then that next day has to see that person in, well, places a church, and that person being in a position of power or authority. Been doing this a long time. That whole concept may seem like it's just something that just happened. Frankly, when one looks at it on the surface, that it's actually, if this is a circumstance where the two incidents, and that's all that I had necessarily before me, occurred, that's not by accident. That is, that whole series of things is by design for a very good reason, because that stops this person from saying anything, doesn't say anything to the parents, doesn't say anything to the people in church, doesn't say anything because of where this happens. And the longer that goes, it becomes more difficult for the person to say something. In just listening to that, looking at what's been laid out by the people of the court, as it indicated, does find that there is a great presumption of the defendant's guilt. It then shifts to show by a higher standard than normally would be applicable in a bond argument of basically a preponderance of evidence, but it shifts to a clear, convincing standard to show that the defendant is not likely to flee or does not present any danger. And that really does shift, in essence, to the defendant to show that, or at least put forth some evidence to the court where the court could conclude that. This court does not conclude by any stretch of the imagination that the defendant is not likely to flee. The court believes that the defendant is in a position of potentially facing life sentences. That also there is a circumstance, and it's a bit unclear, a bit murky, but where he knows that he is subject to at least an investigation and flees, or at least leaves the state. Oddly, where the parent or those that most likely would know where they are, where he is, don't know. And he is there. Counsel may make a good point that the very fact that if he were going to flee, that he comes back. Under what circumstances and for whatever his reasons are of coming back, I don't know. And maybe that's to be told, but this court views that as something where clearly the defendant has connections in other states that he could flee to. I think that the laying out of the number of victims, and not necessarily the numbers, but the number of the acts, make it more likely to this court that the defendant would flee or could flee to that. And the court does believe that he poses a flight risk. I also do believe, because I think it becomes a bit difficult when one is trying to address, does this person pose a danger to another person and or to the community? This court does believe that this defendant, given all of the circumstances that the court now has before it, does pose a danger to the community. I've read all of the letters of support that the defendant does have, and people have good things to say about him. They have good things to say about his family. I make note of one thing that the prosecutor said, and it doesn't seem like it's much, but for this court, it was much, where in talking with Michigan State Police, she either blurts out or says that her son is leading a double life or a separate life. I don't blame her for saying that. I think it may have just been something that she said when she sees everything. And I think that that's true in this case. And so I also think that there isn't, given the magnitude of what the defendant is accused of in this case, that while the court has many tools at its disposal, the court doesn't have the, I don't think, proper tools that would be able to monitor and prevent the defendant from hurting other individuals or engaging in this behavior with other individuals. The only way the court would have to do anything along those lines is certainly to order that, but that doesn't mean that the defendant has to follow it. And then we don't know until somebody else's mental health and or physical health is damaged that it has occurred. And this court is not going to take that risk given the circumstances and what the court is looking at. Taking all of that into account and looking at everything, and now looking at this case with the number of charges, a number of alleged victims, the court does not believe that it be $3 million bond, which was initially set as an appropriate bond. And that under the circumstances, the court now has heard them and now knows the defendant's bond ought and should be denied. And so therefore, I will deny the defendant's motion to reduce bond. I will grant the people's motion to deny bond. Defendant's bond is denied.
Pedo. Accused pedo.
We are also set. Go ahead.
Thank you.
We are also set for PCC. Are we ready to proceed to the next stage in this matter, or we're on?
Judge, I was going to ask court, will you do a written motion on that order that you just made?
You mean a written order?
Yes, sir.
I usually do not prepare a written order. If you'd like to prepare one, you may, and I look at it and sign it. But I mean, in terms of, there'll be a written order denying his bond. But
No, I understand. I just wanted your written findings in the order.
If you really want to appeal that, buddy.
Put on the record.
I'm going to let the record stand. If you want to draft an order, counsel, I will be more than happy to look at it and sign an order if it's appropriate.
Okay. So as far as the PCC goes, again, we just got their supplement report yesterday, number 12.
Still going. I'm going to end here because I'm going to send y'all over to Hella. She's about to start, my wonderful co-host. She is doing a Richard Allen, looking at some of the photographs and seeing if they were photoshopped and how they were manipulated, because she is a wonderful graphic designer for many years. So that starts in a minute. PCC is a probable cause conference. David, no bond. Denied. Tomorrow. Oh, thank you, Nikki. Yeah, I really like Fleischer. So hopefully we'll have some Fleischer tomorrow morning at 10 Eastern, if he's streaming. And then I will probably do some more Judge Simpson or some other judge. But we'll see. Play it by ear tomorrow. But if I do that, that'll be at 4:30 tomorrow. So let me get the redirect, make sure that's set up. Yep, awesome. Alrighty, so yeah, you guys can go watch Ange and Hella. See you. It should go to the Court of Appeals because the judge shifted the burden. Interesting. Well, we'll see. I'll have to keep an eye on it. But all right, guys, I'm going to end now. I will see you guys over there. Bye.